Welcome to our 12th Time4Action webinar. We've had one every week for the last 3 months, and we're on a roll. I'm Ken Johnson. My colleague Kathleen O'Hara, Rolly Montpellier, and I are on the, as well as Danielle and Alex, who are on our panelists. Two of our panelists today are all on the unceded traditional territories of the Algonquin peoples. We have 3 wonderful guests today to discuss suing the government over climate inaction. The first is Dianne Saxe, not stranger to few. She studied at the Osgoode Law School and an LLB and a PhD in law. She practiced law with the Ontario government, working in 2 major law firms, and ran an environmental law boutique firm for 25 years. In 2015, she was appointed the Environmental Commissioner of Ontario for a 5-year term. While she was there, she delivered 17 reports on topics including environmental injustice to the First Nations and endangered species, water pollution, and climate policy. After being elected in 2018, unfortunately, the Doug Ford government decided that she wasn't such a good thing to have around because she was telling the truth. So the Ontario government, of course, rolled back the climate change laws that the Liberals had put in that they were doing very well with, and the cap and trade. And so her position was soon abolished. She then reopened her Saxe Saxe environmental law practice, and she's now the deputy leader of the Ontario Green Party, so another shift. Our second speaker today is Danielle Gallant. She's a lawyer with the climate team at Ecojustice, Canada's largest environmental law charity. Many of you will know it's been around for 30 years. She's a member of the Quebec Bar and is fluently bilingual. She recently completed her master's in global sustainability and environmental law at the University of Ottawa, where she focused on human rights impacts of environmental issues and on climate change litigation. Prior to this, Danielle worked in different fields, including municipal, criminal, corporate law, within various firms and governments. She also had the opportunity to article at an international court for an academic semester. Our third guest is the youngest guest we've had to date, for sure, Alex Neufeldt. She's one of the 7 young people that are taking the Ontario government to court as part of the general climate, hashtag Gen Climate Action case backed by Ecojustice. She's a small business owner and soon to be fashion design student living on an unceded Algonquin territory, of course. And let's get started. Kathleen will interview our guests for about the first 30 minutes, then I'll ask some follow-up questions, and then we'll have Rolly ask some questions from the Q&A, so please put them in the Q&A. Kathleen, over to you. Let's get started.
Thanks, Ken, and thanks to our viewers for joining us again. And thank you to our 3 wonderful guests, heroic guests, I would even say. Taking the government, any government to court, generally, is a challenge. So my first question is, what motivates you, brave 3? Can you start, Dianne?
Oh, well, what motivates me is I am passionately concerned about the collapse we're causing to natural ecosystems on which our lives depend and the rapidly arriving climate crisis. I have children and grandchildren, and even I can't be sure to die on time anymore. So as Ken said, I was the Environmental Commissioner of Ontario, which was a wonderful job, and I would have loved to spend the rest of my life doing that. And in that position, I had a real privilege to provide oversight on 17 government ministries. And until 2018, there was a lot to be proud of. And Ontario had a lot to be proud of, for sure. I never ran out of things to criticize, but on the whole, we were making progress. And then once the Ford government was elected, they proceeded rapidly, steadily, and are continuing to this moment to attack, damage, defund, demolish, undermine every statute, person, institution, or process that's worked for climate environmental protection or stood in the way of big developers making a whole bunch of money in the short run. So we're in trouble, and our government is leading us rapidly in the wrong direction, and the decisions they're making are really long lasting. If you build a highway over the greenbelt, you never get back what you had before, or at least not for a very, very long time. So I am working urgently because I think everyone my age owes it to the young people to do everything that we can. Most of this damage occurred on our watch. We need to do what we can to undo it. Kathleen, you're muted.
Thank you, Dianne. I know. Danielle, can you just give us a short outline of what motivates you? Because you're taking on a big, tough government in this case, and you are an environmental lawyer generally. Can you just give us a sense of what motivates you?
Yeah, absolutely, Kathleen. So, I mean, I got involved in public interest environmental law because I gained this understanding that environmental issues, and most particularly climate change, they don't affect everyone equally. They have disproportionate impacts on certain vulnerable populations, and they perpetuate existing inequality. So that was a huge issue for me to get my mind around and to consider how I would put my skills to addressing this issue. And so that brought me to be involved in this case as a lawyer. I would say that going forward, I'm also very much moved and inspired by the applicants in this case. Everything that they've told me about their own concerns and the own action that they're taking on climate has been really inspiring. And so I'd say that's another piece that motivates me to keep working on this case is hearing their stories and helping them to elevate their voices, both in the court and outside of the court as well.
I keep getting muted. Alex, you're one of the 7 heroes in this case. Can you tell us what motivated you to start out taking on the Doug Ford government?
Of course. So first of all, not living on a hothouse earth or dying of some climate-induced catastrophe motivates me quite a bit. Because that's obviously what's at stake here with climate change. The consequences have the potential to be disastrous. But aside from that, I really think that Ontario could be and should be a leader in fighting climate change and creating green jobs in the process. There's so many smart, talented, skilled people in Ontario who I think are really willing to step up and contribute to a green transition in this province. But the Ontario government, the current administration, I feel is taking us in the total wrong direction and squandering all of that potential. So those are things that motivate me quite a bit.
Oh, you're muted again, Kathleen.
Why take the legal route, Alex?
In my opinion, because quite frankly, we're running out of time. So I feel that we need to take every technique in our arsenal to try and make change because we only have so much time left. So that's why I think we have to try everything, and the legal route is one of those routes that we can take.
Danielle, why take the legal route? I mean, I know you're an environmental lawyer, but what can it do that protesting in the streets or petitions or whatever, building a mass movement, what can the legal route do to either supplement or replace some of those actions?
I think that's a really important question to contrast the route of litigation versus all the other ways in which we can act on climate as a citizen, because it's true that it's not always necessary to take a government to court. There's often other ways that you can attempt to raise your voice and have your government act on climate. However, there's some cases in which government has so clearly stated that they've set intentions that they will not take adequate action on climate change, where citizens have realized that, taking their government to court is the last action they have remaining to them to address this crisis, as Alex put it. And so, just given the lack of time that we have to put these actions forward, litigation sometimes occurs as a way to hold your governments accountable for the lack of action. And so happy to discuss how this manifested in our case, perhaps a bit later in the conversation, but there are some cases in which it's very clear that government will not listen to its citizens otherwise. And so going to the courts to impose a court sanctioned order might be the only resort left.
Dianne, why the legal route?
Well, I agree with both of those comments. I mean, first of all, I do think litigation is one of the last resorts. It's not the ideal way to make climate or environmental policy, but when it's really late in the game and you're losing, we have to try other things, high risk, high reward strategies. And litigation is one of those. The courts traditionally have usually refused to get involved in these kinds of problems, but every once in a while they have, and that's made a big difference. Courts have immense power, they have legitimacy, they get media attention. When they say something is a fact, many more people accept it as a fact. And so, you know, in the acid rain days, most of the acid rain litigation, possibly all of it in Ontario, failed, but it still had a big impact on public opinion, on politicians, on awareness of the urgency of the problem, and that led ultimately to a political solution to acid rain. I don't know what's going to happen in these cases, but I'm strongly in support of them because we're at the stage now where we need to try absolutely every single tool we have. And this is one that can have a big reward.
Dianne, you know about the Netherlands case. Could you tell us about it? Because that's a success story.
Well, absolutely. There have been a number of important success stories around the world, but the leading case is the Agenda case, where a non-governmental organization in the Netherlands sued the Dutch government for making all kinds of climate commitments internationally, issuing press releases, signing communiques, and so on, and then happily going along allowing emissions to continue to rise in the Netherlands. And so this was the first major case where the courts accepted jurisdiction and actually ordered the government to take action to meet the international commitments it made. And that decision was upheld all the way up to the Dutch Supreme Court, which has then forced the Dutch government to change its approvals on a series of activities, including agriculture, which has immense political power in the Netherlands. So the Agenda case is the flagship case around the world. We've had others, a very important Irish case last year, which is mentioned in that article I gave you the link to, where the Irish Supreme Court ordered the Irish government to go back and redo its climate plan, where they had adopted a law saying they would have a climate plan that would do certain things, and then they did very little and greenwashed it, much as Ontario has. And the court said, well, you can't do that. So it's really exciting to see the courts being willing to step in. And I think the biggest reason is because when we were talking about polar bears and future generations, that wasn't something that where the courts felt they had jurisdiction. But once we have a current threat to people alive now here, that's something that the courts will pay some attention to. And it's great to see that starting to happen.
Thanks, Dianne. I think Rolly's going to post a link to your article.
Thank you.
Danielle, let's start looking at the young people's suit in Ontario. How did it come about, and what are you arguing?
Yeah, thanks for that opportunity to discuss the case, and maybe I can provide some context, and Alex can follow up regarding her involvement. So what prompted this lawsuit was that the government of Ontario repealed the previous and fairly ambitious targets for 2020, 2030, and 2050, which were set under the previous government's climate law. And these were repealed through the Ford government's Cap and Trade Cancellation Act in 2018. So the government then replaced those targets with one inadequate target for 2030. So essentially the government backtracked on its ambition to fight climate change at a time where we know that all governments have to act more to combat the climate crisis. And we also know that this 2030 target is not in line with what the scientific consensus is on what we must do to avoid a dangerous degree of climate change. And we argue in this case that will cause catastrophic impacts in the future, which impact Ontario youth and future generations, their fundamental rights under the Charter. And so this case was launched in November 2019, and it's being brought on behalf of 7 Ontario youth, as you mentioned, and obviously Alex is one of those youth. And these youth range in age from about 13 to 25 years old, and they've all been taking action in their own capacity to fight climate change and also share a common concern about what their government is failing to do on climate change.
Alex, can you give us your take on how things got started and how you got involved?
Sure. So I mean, I wasn't the first person involved in this. I'm not exactly 100% sure whose idea it was, but I remember one day I got an email from Rolly, actually, who's one of the organizers of this event. He said, "Hey, Alex, some young people are gonna sue Doug Ford. Do you want to get involved?" I said, "Yes, that sounds great." So then I had a call with Danielle and the rest fell into place. So that's how I got involved with that. And yeah, like Danielle said, essentially we're arguing that the emissions reduction target that this government has set is too weak. And if I'm not mistaken, Danielle, correct me if I'm wrong, we feel that this violates our right to life, liberty, and security of the person under the charter, which is a big deal. So it's really exciting to be involved in this monumental case.
Dianne, having been fired by Ford, again, you must have been thrilled to hear about this case.
Well, it's not because I was fired. It's because we do need people to stand up and fight for climate action. And this is an important way to do it. I was really delighted to read Justice Carol Brown's decision in November, where she allowed the case to go ahead, because that's the first battleground for every climate case and most environmental cases is, will the court allow the case even to go to trial? And in this case, the Ford government, you know, the lawyers repeated the nonsense of the Ford government, putting the science in question, putting the science in quotes, casting doubt in a very Trumpish fashion on, like, what's all the bother here? We are the government. We're entitled to do what we want. Get out of our way. And it was wonderful to see how carefully and precisely Justice Brown walked through the government arguments that, you know, you can't get in our way, and pointed out really clearly it's true that under separation of powers, we have three different branches of government: the legislative branch, the executive branch, and the judicial branch, and each one is supposed to respect the job of the other. But the Canadian Charter of Rights and Freedoms changed that balance in a dramatic way, that although governments have a right to make social and economic policy, they also have an obligation to respect the charter rights. And so because she found that there was a plausible claim of a charter breach, then it's within the court's jurisdiction, even though judges are profoundly ill-equipped to decide how government should spend money and so on. But nevertheless, if it's a charter breach, then it's like a judicial issue. So then we had the great good news where the divisional court refused to intervene with that. So which means this case is going to trial, which is wonderful. That's really good news. It means the government is forced to put, yeah, it's really good news. It means the government's forced to put its evidence forward. It means there's going to be a public trial. It means there's going to be lots of media attention to the evidence in the trial. I hope we see even more attention there than we've been getting to the Chauvin trial. It's really, really important, and it's a rare and dramatic opportunity to get the facts, get the science in front of the people, and also the very weak excuses that the Ford government has used.
Danielle, the judgment or decision last month that it could go ahead, is that a precedent or is that historic?
I mean, we would definitely say that it's historic. And I mean, Dr. Saxe has already touched upon this, but maybe I can provide a bit more context. You know, as I said earlier, we launched the case in November 2019, and fairly immediately after that, the Ontario government filed its motion to strike. So as Dr. Saxe was stating, you know, the implications of that motion, if they had won, were to throw out that case before it went on to a full hearing, and that we had the chance to put forward the really important evidence on the ways in which climate change will harm youth and future generations if it's not adequately addressed now. And so, you know, this was a really important hurdle for us, not particularly surprising, because this tactic has often been employed by government against these types of, novel lawsuits. They are raising fairly new points in many ways. And so that wasn't a surprise to us. The other youth climate cases occurring in Canada also faced similar hurdles. On the other hand, it really provides an opportunity for the youth bringing this case to have an early win and to be able to set important precedents that will then be potentially considered in other lawsuits throughout Canada. So it also provides an opportunity. And that's exactly what happened here. In November 2020, that's when we found out that Ontario's motion had been rejected on all counts. And as Dr. Saxe said, it was a really well-reasoned decision that really dealt with each of their arguments very, with great reasons and logic. And it really was the first decision in Canada where a Canadian court ruled that climate change can threaten Canadians' fundamental rights and that citizens have the ability and the right to challenge their government's actions in front of a court. And so we say it's historic for that reason. And then after that decision came out, the government applied for leave to appeal that decision. And then thankfully, a few weeks ago, we received the good news that that application was denied. So as Dr. Saxe said, this means we're going forward to a full hearing, and it's a very exciting development in our case.
Alex, you must be excited. You're on the way, possibly to victory.
Yeah, super exciting. So back in November when we got the news that the motion to strike was shut down, or I don't know what the technical term is for that, but when the judge ruled in our favor, yeah, that was so exciting. I had no idea which way it would go. I watched the whole hearing along with our lawyers and the other applicants. We tuned in on Zoom, and I remember thinking that there were strong arguments on both sides, and just hoping it would go in our way, and it did. And that was such an exciting thing. I told all my friends and family about it, and one friend in law school told me, she was like, this motion to strike is going to be in legal textbooks, like future students are going to learn about this. So that it's so exciting, absolutely, to be involved in something so monumental. And then when we got the good news in March that the leave to appeal was not granted, I kind of assumed that was a formality almost, and that was something that was going to be. Dr. Saxe's, no, not at all. So I was wrong, clearly, because yeah, that was not granted. And actually that we got that news on my birthday, so that was a very nice birthday gift to me.
Thanks, Alex. So if in best case scenario, the 7 plaintiffs win, how far does it go up? Sorry, I don't know my legal system, but you won't be taking this to the Supreme Court, will you? Or how does it work from now, Danielle?
Yes, I mean, the next steps in this case, are that we will be trying to get this case to a full hearing as quickly as possible. So for now, we've only been debating the motion to strike. So that's taken up the whole proceedings of the lawsuit, but now we'll be moving forward to a hearing where we'll actually be able to put forward our legal arguments as well as our evidence, which, as I've mentioned, is very important here to show exactly how climate change will impact those fundamental rights. And so we don't know yet when this hearing will occur in the future. It's a bit early to know that, but Ecojustice lawyers are hard at work to prepare and submit that important evidence so that it's in front of the courts. With regard to what would happen after that, it's a bit speculative at this point, but it is very possible that a final decision on this case could be appealed up to the Supreme Court. The Supreme Court is often the level that decides the very contentious societal lawsuits, and this could very well be one of them. So I'd say it's not entirely out of the realm of possibility that we would be arguing this case in front of that court, but there we would be able to set an even more powerful precedent on climate action. So it'd be a very exciting development for our case if we got there.
Dianne, after all your experience in law, how do you see the future? As Danielle said, but do you see it possibly going to the Supreme Court?
I think you can count on it. This would be one of the most important decisions the court's ever made. If they uphold this case, we I hope everybody who's listening understands how pervasive the transformation needs to be for us to actually do our part to try to keep a stable climate. So there will be winners and losers. And the losers have a lot to lose and a lot of reason to fight, as we've been seeing for the last 3 decades. So yes, I think we could be quite certain that if the court ultimately orders the government to do something serious on climate, then first of all, let me start this again. I certainly hope that by the time the court makes its decision, we have a different provincial government. The court procedures are almost always slow. We're almost halfway through the Ford term, and so there will be another opportunity for the people of Ontario to choose differently, and I hope that they do. And that, of course, would have an enormous amount to do with the case as well, because if you got a climate responsive government, you would not necessarily be fighting this case all the way. Hopefully, there'd be an opportunity for a settlement to get on with actually doing the work. But who knows? The federal government does some good things on climate, but is still fighting the litigation there for reasons which completely escape me. But yeah, I think, Danielle, you've got a pretty good chance of ending up at the Supreme Court, but I hope that enough other changes made that you don't need to.
Oh, you're muted, Kathleen.
What did you mean about litigation in terms of the federal Liberals, Dianne?
So there were 2 youth cases started roughly the same time in Canada. This one, Mather versus Ontario, brought against the Ford government for its actions in repealing our climate law and setting a very weak target, which we know it is basically no different than where we are now. At the very same time, a group of young people from across the country brought a case called La Rose against the federal government, seeking a court order requiring the federal government to basically take serious action on climate. And they met the same preliminary motion, the same defense from the government saying you should throw this case out. I tried hard to persuade the federal government that they should not do that, that if the prime minister and the cabinet believe the things they say, and we hear all the time they're talking about how important climate change is. Well, they should have allowed the case to go ahead. Most of the factual assertions in the case are based on the government's own evidence. And nevertheless, they have fought against these young people, and they've successfully persuaded a court to throw the case out without trial, and that's now under appeal. It's a very foolish decision, especially given the minority position of the Liberals, and they know that there's always another election coming along. And one of the big problems in climate action is these flip-flops, that you get one government and then another government and the rules keep getting changed. And that's a very bad news for long-term investment, which we need to get serious about big issues. So the courts have the ability to make rulings that don't get overturned when the government changes, and that's a really valuable tool. So anybody, one useful thing you can do is write to your MP and urge them to consent to the appeal and allow the La Rose case to go to trial. That could be tremendously useful.
Maybe just to provide a bit more context, just to regarding the kind of general state of climate litigation in Canada, there's also a class action suit being brought in Quebec on behalf of all Quebecers 35 and under. So that's also against the federal government. That one, unfortunately, just due to the class action procedure, it did not get certified for class action, but that's also being appealed. And there's also a 4th climate case being brought against the federal government as well on behalf of Wet'suwet'en clans, heads of clans. And so that's an Indigenous-led climate case also against the federal government, which has met a similar fate to the La Rose case, and that decision is also under appeal. So there are sort of concurrent cases being brought against the federal government, while the Mather case that Alex and I are speaking to are brought against the provincial Ontario government. So one of the key distinctions.
Is there one central spot? I know you're Ecojustice, and Ken is going to ask you a bit about Ecojustice, but is there a place where we can go to have, is there a court watch or something? We need a place where people can go to keep up with these things so we can all help support them, because I mean, we've heard about the carbon tax decision, but the media usually don't cover these things terribly well. On that note, does anybody have anything else to say on what we were just chatting about? Or I'll pass it on to Ken for a few questions.
Kathleen, just one suggestion.
Yes?
Don't call it carbon tax. It's not
Oh,
a
I know.
tax is money that goes to the government. None of this money goes to the government. So carbon price.
I know. Old habits die hard. Okay, carbon pricing. All right, well then I'm going to pass it on to Ken and thank the three of you very, very much for wonderful answers. Thank you.
Thanks, Kathleen. Can people hear me? I hope it's not garbled. Apologize very much for earlier. I think I'm going to write an opera called You're on Mute when this COVID thing ends. And anyway, I apologize for the technical problem. I hope everyone can hear me well now. I'd like to, thanks Kathleen, I'd like to ask Danielle and Dianne a little bit more to explore the Supreme Court's carbon pricing decision. And Dianne, could you speak first to the significance of that decision overall and why you think why they were successful?
Well, it's hugely important, first of all, in reinforcing the right of the courts to get involved in this issue at all. Remembering how many times the courts have refused to get involved in environmental issues and just said it's not an issue for us. The second thing is because the courts made really important findings of fact. Not that these should have been surprising to anybody who's following the science, about how serious climate change is and how seriously it threatens Canada and Canadians, and particularly Indigenous people in coastal and northern communities. But nevertheless, it's really useful to have the highest court in the land make findings of fact on these really key threshold issues that are still so denied by so many people, including trying to put to bed for once and for all this argument that I keep hearing people say, well, Canada, our emissions are trivial, they don't matter at all. Well, in fact, we're as a country, we're one of the world's worst climate polluters. So we've got really strong findings of fact. We've got a strong support for federal government jurisdiction, at least in the area of pollution pricing. The federal government, in the Canadian constitutional system, the federal government is comparatively weak. Most of the constitutional powers that are most relevant to climate and environmental issues are provincial. And as you know, the major polluting provinces in Canada are Ontario and Alberta, and both are led by very right-wing conservative governments that have taken very strong action against climate and environmental measures. So having at the moment with right-wing provincial governments and a somewhat climate concerned federal government, it's really good to see the federal government have more power. If the situation were reversed, if we had Harper still as the Prime Minister of Canada and we had strong...
I'm sorry, Dianne, you're not allowed to say Harper on this particular telecast.
Oh, I apologize for that. Well, I mean, I could make it worse. Imagine if we had, say, Mr. Ford as Prime Minister. But in any event, you can imagine a situation in which those of us who care about the future of the climate environment would not necessarily want to see the federal government be able to preempt the provinces. But in the current political constellation, it was very good to see the federal government get authority. And it also takes away the fig leaf that the federal Liberals have used as their Climate Accountability Act, which doesn't actually create any accountability and is a very weak act. Well, one of their rationale for that was, well, it's not really clear what our authority is. So now their authority is a bit more clear, which makes it more clear that what we have is a political problem, not a legal problem.
Just to follow up on that, why do you think the federal court, like I always think of the Canada's federal Supreme Court as fairly relatively progressive. I don't know, maybe that's compared to the US one, but I'm surprised that they are so unwilling to take up these cases in this time, especially given the context, the time.
Yeah. Well, I mean, first of all, judges can't just freelance. They have to work within a 150-year tradition of case law. And the case law, a lot of the case law in Canada over the last 150 years has been quite hostile to federal jurisdiction and have tended to uphold provincial jurisdiction instead. The second thing is there's a real division of powers problem here. The judges are, by training, experience, resources, background, I mean, they're just not in a good position to be making large trade-offs between different parts of the population, which they now do under the charter. But you have to remember who the judges are. They're not elected. They're not accountable to the people. They don't generally have economics training or anything other than law. They don't have research staff who are knowledgeable in economics or finance. They don't have to deal with the fallout of their decisions. And so there's a lot of reasons why the courts really should be slow to slap down government legislative decisions that have been made following proper processes. And what we're seeing now is that as the climate and environmental crisis gets more and more dire, people like me are getting more and more willing to cross those boundaries because so much else is at stake. But there are real disadvantages to having big social decisions made in the courts, including the fact that while money has immense power in elected governments, it also has immense power in the courts. It makes a huge difference who can afford to get good experts and good lawyers. A lot gets done with volunteers, a lot gets done with very little money by groups like Ecojustice, but their resources are always stretched thin. So there's a lot of disadvantages, but we need it now, and I'm really glad to see the decision that we've got at the moment.
Thank you. Danielle, would you like to follow up from where Dianne left off and situate the carbon pricing reference decision for the case with the young people?
Yeah, absolutely. I mean, as Dr. Saxe explained, that decision was really rendered in a completely different context than the case that we're bringing. It's a question of division of powers, whether the federal government had the ability to price carbon throughout the country. So very distinct issues. However, there haven't been that many climate cases in a broad sense that implicate climate change in front of the courts just generally. So whenever there's a finding made in a case that's often very relevant for these kind of new novel cases regarding, the obligations to fight climate change. And so while these decisions, that decision was in a very different context, it's certain that some of the findings that were made in that decision will be relevant to our case. And just to provide an example, in Justice Brown's decision from last November, rejecting the motion to strike, she referenced the Ontario Court of Appeal decision in the same reference series to show that certain facts regarding climate change can be predicted with sufficient accuracy. So we know that some of the findings that will be made will definitely be relevant for these types of climate cases. For instance, the Supreme Court confirmed certain important issues like the fact that climate change is a grave threat to humanity's future. It said so in those terms, that it has to be addressed through reducing GHG emissions, and that each province's emissions contribute to the climate crisis. So that's very relevant to the case against the government of Ontario. And so we will certainly be reading that decision, keeping in mind that, where we can use any of those findings, we will try to.
Thank you. Alex, I was wondering, just from a young person's perspective, you and your friends, how you feel about this whole court thing, how optimistic are you, or what have you already learned about the court system? I'm learning stuff today that, can't count on the court so much. How about yourself and your friends?
The first thing that came to my mind for some reason when you said, what are you learning about the courts, was when we were watching the motion to strike hearing and all of the formalities that went into that, like the something about the Queen was said. There's like the funny like hats and outfits that people wear. So yeah, anyway, I thought calling opposing counsel my friend. So yeah, I've learned really insightful and interesting things about the courts clearly thus far. In terms of just how this whole experience has been so far and whether we're optimistic, I mean, I can't speak for everybody, obviously, but I think it's just really been a very rewarding experience to be working with the whole team at Ecojustice, who has been so good about supporting us and representing us so wonderfully. And then my fellow applicants as well, who are all brilliant and so engaged in what they're doing and care so much. It really does make me optimistic. And I mean, I talk with people about this case, and a lot of people are like, oh, well, it's very unlikely that, you'll get a victory and you'll get what you're asking for. But there's all of these other goals that, are good about this. And that's all true. But I do feel when I'm, spending time with the people at Ecojustice virtually or in person, and with my fellow applicants as well, I really do feel like we're gonna win and do big things because everybody's so committed to what they do, and it just fills me with a lot of hope. So I mean, as far as what happens with this case, we'll see, but I think regardless, we've already got a win with the motion to strike. That was amazing, and I think this is going to be an important case regardless of what happens.
Thank you, Alex. I think you've already learned the most important thing that can come out of this is action creates hope, and lack of action creates despair. Let's see, Danielle, do you want to locate this particular case with the young people into Ecojustice's larger work more generally?
Yeah, absolutely. So, I mean, this case is Ecojustice's most ambitious climate case yet, but it does fit into the broader context of what Ecojustice does as an organization. So to repeat our mission statement, Ecojustice uses the law to defend nature, combat climate change, and fight for a healthy environment for all. And the ways in which we do this is both through litigation and law reform initiatives. So in this case, obviously you're bringing the case through litigation, but we also try to change the law to make it better. So whether that means challenging the lack of enforcement of species at risk provisions or measures, challenging the lack of public consultation when the Ontario government repealed its cap and trade system, or fighting for a federal climate accountability law, we see the law as an important tool in addressing pressing environmental issues and protecting Canadians. So if you're interested in learning more about what we do, I would encourage you to visit our website, ecojustice.ca, and also sign up to receive our email updates. They're really helpful and informative. I even receive them to help me keep informed about what my colleagues are up to. And just show your support for these cases, for the youth in the case that we're involved in, but also in the other cases that are happening throughout Canada.
Thank you. I've been a long-term supporter of Ecojustice because I think they do great work, but I went to the website recently. I hadn't realized, I think you have about 30 wins under your belt on important issues that you've taken up. So thank you. Dianne, I'd like to turn one more time to you and ask you, you've been in the trenches with this work for a very long time and have a remarkable amount of knowledge, of course, because of all the incredible work you've done here. I'm curious where you fit right now in terms of optimism or pessimism about where we're going, particularly in Canada, and whether the governments are going to step up to the plate. And just one sub piece of that, could you make it clear to people, if they win in the court, can you actually make Doug Ford move? Can you make Justin Trudeau actually step up to the plate? Because they all say they're stepping up to the plate. And then when they say they're stepping up to the plate, it doesn't look so much like it. In fact, we still haven't started, the Liberals have been in for 5 years and we haven't even started to reduce our carbon footprint. So anyway, just your more general thoughts.
I mean, the short answer is yes, court orders can actually change the rules. We've seen that in the United Kingdom. We've seen that in the Netherlands. Yes, it can work. It would be astonishing. I mean, we're more likely to get a declaration than a court order, I would have thought in this case. Again, thinking about the division of powers problem as between judges and the legislature, even if the youth plaintiffs win, it's more likely that the court will just say, the government is wrong, they should do something different, as opposed to, and what they're doing now is endangering the charter rights of young people, as opposed to actually ordering the government to act. That doesn't necessarily produce a result. For example, when Greenpeace took the government to court for breaching the Environmental Bill of Rights, the court said, yes, the Ford government had breached the Environmental Bill of Rights, but didn't issue a remedial order, and nothing changed. The Ford government is still happily breaching the Bill of Rights. But I think it would make a difference to public discourse, to people's understanding, if we had a judicial finding upheld by the courts that the climate indifference and destruction of the Ford government was putting the charter rights of young people at risk. Among other things, it would mean really different dinner table conversations, I think, for young people. A lot of different things have to happen for us to actually make the kind of transition that we know we need to do. We need people in the streets. We need people in the courts. We need people firing their banks. We need people inventing new technologies, like the inventors and the entrepreneurs that I interview on my podcast, Green Economy Heroes. We need singers singing songs about climate. We need everyone bringing what they can to this battle for our lives. And if we pull it off, it will have been because of many, many different people doing many different things. All of us doing as much as we can, as fast as we can. And that's the only chance we've got. So we have to do it because the alternative is terrible. I do it for the people I love. And that's what we all need to do. Everybody, no one can do everything. Everybody can do something. And if we all do something, we might pull this off.
And are you optimistic?
I'm optimistic in this. There's two ways of thinking about optimism. One is to think that, oh, well, it's going to be fine by itself. I don't need to do anything. I do not have that. But in terms of the kind of optimism that says, no matter what the facts are, it's not 100% sure. We still have the possibility of change, and therefore I will work for change. And that's why I've turned my life upside down. And after an entire lifetime of carefully avoiding political entanglements, I'm running for the Green Party for the provincial parliament in Ontario. It's a long shot, just like these lawsuits. It's hard work and expensive and difficult and all those things, just like these lawsuits. But maybe it'll help. And so that's my optimism. I've turned my life upside down to step into the political arena, and I'm looking for people's support.
Thank you. I'd like to turn it over now. Thank you for all those answers. I'd like to turn it over now to Rolly to ask. There's a number of questions in the chat or in the Q&A, and I'd appreciate Rolly taking over and asking the questions.
Thank you, Ken. There is a ton of questions in the Q&As, and there's no way we're going to get through all of them. So I've tried to.
Rolly, that's why we put you in that spot, man.
I know. So here we go. But before I go there, I just want to remind everyone who's been following the chat that I put links to Ecojustice. There's also an email link that you can, I think, sign on to get updates on the court case. I put some links as well. Dianne Saxe Saxe. Boy, that's a complicated one. And so yes, there's a lot of information there. And thank you for some of the great comments. And I'm just going to read one here. And I kind of like it. So it was from, it doesn't say, I think it's anonymous. Anyways, it says, thank you, Dianne. I've been listening to Federal Energy and Natural Resources Minister Sean O'Regan. And she goes on to say that she thinks the Liberals have no intention of getting off reducing their being cheerleaders for the oil and gas industry. But getting to the questions, so I'm going to actually read the question. There's one from, well, I'll start with Tom Cullen. Tom sort of has a two-part question. Even with a court decision in favor of the applicants, what might the decision say and what would it really force the government to do? And there's another question from someone else along the same line. So what's the best case scenario? What could we get out of this case? And how would it force the government to move?
So I can take that on.
Yeah, yes.
So the remedies that we're seeking in this case include an order to require Ontario to set a new science-based target. So it would no longer be able to simply set a target that doesn't respect what the science tells us must be done to limit global warming to a safer degree. And we're also seeking an order that they set a new climate plan according to that target. We're also seeking declarations that when the government fails to act, it infringes upon Ontarians' fundamental rights to life, liberty, and security of the person. And also that those fundamental rights that I've just mentioned incorporate a right to a stable climate, because how could you have a right to life, physical and mental security and liberty if there's not a safe climate to live in? And so ideally, if we won and we were granted all of the remedies that we sought, Ontario would have a new target and would have to act according to that target. We'd also have a very important precedent set in front of a court that governments in Canada, who all have to act pursuant to the Charter, cannot simply fail to act on climate and infringe upon their citizens' fundamental rights. So it would also have importance outside of Ontario.
Dianne, did you want to add to that, or?
No, I think Danielle put that really
Okay.
well. It would be immensely important. Another thing, though, that I would add is that the government has been able to just duck and weave and use the COVID pandemic as an excuse while it's driven through more and more pro-sprawl rules, more and more destruction of the conservation authorities and other sorts of things. And one of the advantages of litigation is that it does force the government to actually answer questions on the record and to provide whatever evidence they rely upon. And that's going to be really interesting because as far as I could tell as commissioner, the government didn't have any evidence that it relied upon. The so-called Made in Ontario Environment Plan is, it's a combination of taking credit for what other people are doing, misstating the facts, and making big promises that they're not keeping. So it was the process of the trial itself, the extraction of evidence, the opportunity for cross-examination is going to be just fascinating. And I hope we'll give an opportunity to give lots of people a chance to really look at how we're being lied to.
Thank you both for that answer. I had a similar question from someone else, Jeffrey Levitt. Jeffrey, I hope that we've been able to answer your question. It was very, very similar. I also have one from Don Ross. And Don says, as I sit here in Milford listening to this webinar, which gives me such hope, I'm also listening to the sounds each day of the machines destroying our White Pines wind farm around us. Is there some way that this Cancellation and Dismantling Act, passed within months of the election, be integrated into the legal case to show yet another reckless way this government is destroying the future of our youth? So I guess what he's asking is, are there any other actions by government that can be sort of piggybacked onto this particular case?
And part of the difficulty that we have is that there are so many. Government is, with their ministerial zoning orders, is destroying critical habitat right all around the province. We have, there's just a blizzard of terrible things being done. The changes to the growth plan, enormously harmful. And there just isn't enough volunteer time, money, and bandwidth to fight it all. This case is sucking up, I don't know, thousands and thousands of hours of time, a lot of volunteer time, a huge amount of public money. You can't do it for everything, even if the courts were open to everything, which they aren't. So it's really, really important to vote. It's really, really important to speak up and to embarrass this government, to call them to account. It's hard in COVID when we can't be in the streets, which was having some impact. But yes, people need to understand that enormous harm is being done right across this province by the Ford government for their friends, the big developers, in ways that will have long-term consequences. And the law can do a little, political action is going to have to do a lot of the rest.
Thank you for that answer. Very
Rolly,
quickly. Yes,
Rolly, sorry
yes.
to interrupt, but Alex has to go at 2. Is there
Yeah.
anything for her?
Well, yeah, I have a question which is going to Alex and to Danielle, and it's from Erica Walker. And Erica, and I'm sure all the viewers want to know, can we have a link to write to our MP regarding the federal case? So what would be the best way for people to take action? Well, we've already, there's always a follow-up email, and we'll list the ways that people can take action following this webinar. But is there a particular link, Danielle or Alex, that people can sign on to write to their MP? Is there like a template letter that they can use?
I'd say that I'm not aware of a particular letter writing campaign relating to this case. However, you can go onto our website and indicate that you stand with the applicants in this case. So it's a symbolic gesture, but just to show the amount of public support that this case has. It's not just these 7 youth standing up. It's all of Ontarians that are concerned about these issues. So I would strongly encourage you to write to your MP independently. You always have that right, but yes.
Okay,
so
thank
please
you.
sign our petition. That'd be very helpful.
I've shared those links. And Alex, like, are you staying in touch with the other plaintiffs, and are you sort of on social media, supporting each other, or at least drawing more attention to the case?
For sure, we're all on Instagram and Facebook talking to each other and keeping in touch. So yeah, it's very important. And of course, posting updates when they are available. And if anybody else is interested in getting updates as the case progresses, follow Ecojustice on their socials or sign up for their email, because they keep everybody abreast of what's going on.
Thank you all for answering these questions. I'm sorry that we couldn't get to all of them for all of you out there.
I'm going to sign off. So thank you so much. And yeah, let's do this again sometime. I know you do it a lot, but you can invite me again.
Thanks, Alex.
Will do.
Thanks,
You're
Rolly.
welcome.
Thanks, Kathleen. Lovely to see everybody. And yeah, absolutely, Rolly, if you need some help drafting a letter to the federal government, maybe do a draft and send it to me, and then you can put it on your website. Take care.
Thank you for that,
Bye,
Diane.
everybody. All right.
Thank
Bye.
you so much, Diane. We appreciate you being on very much.
Bye-bye.
And to keep up the good work. Thank you.
Thank you. You too.
Thanks, Diane.
Okay, Kathleen, do you want to
Yes.
talk
Danielle.
about the webinar next week?
Okay.
Sorry, Rolly, you had
Okay.
some-
No, that's fine. That's fine.
Rolly, do you have any questions specifically for Danielle? Oh, okay.
I just wanted to thank her because Danielle and I have been sort of emailing and talking about this case even before it started. And that's how I guess Alex sort of got on that list. So it's nice to see you in person, Danielle.
Yeah, nice to see you as well. Thank you so much for inviting me and to highlight this case and the important issues that it involves. So really appreciate you doing that.
Thank you very much.
Thanks, Danielle.
All right.
Okay.
Well, next week, we're going to talk to 2 longtime progressives about the report they put together recently called The Liberal Climate Action Formula, a Recipe for Failure. That's pretty clear. As members of Seniors for Climate Action Now, SCAN, Terry Moore and David Robertson spent hours poring over the Liberals' climate plan announced last December, plus a few other climate-related announcements. We keep hearing them and they just seem to, vanish. And they weren't impressed. In fact, they're very worried. The scary thing is that 70% of Canadians think the Liberals are doing a good job dealing with the climate crisis, in spite of what we just heard today, the fact that they haven't cut emissions. And also, again, referring to what I think Diane said, they're promoting natural gas, hydrogen, and small nuclear reactors. So they're hanging on to fossil fuels in spite of their green words. And so please join us next week to hear from Terry and David about their research. They've got a huge long report. We might put a link to that. And it's such impressive research, and they could take it to court and win. Anyway, over to you, Ken.
Okay, thanks, Kathleen. Okay, well, I guess we'll just end it. Thanks so much. We had more than almost 150 people sign up for this particular webinar, and we've had upwards of 90 or 95 actually attend. Of course, we'll send out a link with the YouTube video in a day or so. And we really look forward to the next couple of weeks. We also have Martin Lukács in a few weeks, and we're going to have Riel Laverne who's working on this NDP Green Alliance for the next election, strategic voting. Anyway, thanks so much for everyone. Sorry about the audio-visual problems. I'm going to fire the guy who's running the Zoom and the audio-visuals later today. Anyway, appreciate you all being with us. We'll see you next time. Bye for now.
Thank you, Danielle. Bye-bye.
Thanks, everyone. Bye.
Thanks, Danielle.